Whoa, we're only seconds into this hearing, and the judge is already signaling that he doesn't buy the defendant's explanation. In court, credibility is everything. Once a judge starts questioning your story, every answer afterward gets put under a microscope.
Write that down on your docket. Write that down on your docket.
Justice interest that would be furthered by modification of what is already very low cash.
Your wrongful jailing is $500 or $5,000 a day. I'm cool with it. I need the paycheck.
This is the expedited misdemeanor docket in Butler County, Kansas, on June 5, 2026. I'm David A. Rickey, District Judge, filling in for Judge Joe Lee, who's absent today. I see someone being seated at the detention facility Zoom location. Who is located at the detention center Zoom?
Keith Brundage.
Stating your name, sir. Thank you for stating your name, sir.
I got a June 10th and a June 6th, and there's no Augusta in here. I got a criminal trespass and a police brutality from Augusta. That's not on the docket, and it should be. That's not on the docket, and it should be.
All right.
I've already filled out the paperwork. I've already filled out the paperwork and everything with Augusta.
We may or may not address that in due course. I'm going to go ahead and call the case of State of Kansas versus Heath Aaron Brundage, case number 2026 CR 169. Darren Patterson appearing as defense counsel.
I don't want David Patterson as my offense. He's not Darren. He's not my lawyer.
Jared Regier appears on behalf of the state of Kansas.
He's $40,000 of crooked. He's $40,000 of crooked.
Have you even talked to Mr. Patterson about your case?
I'm not going to talk to him. He was trying to railroad me.
All right, the current charges before the court in this case are criminal trespass, 2 counts.
And the evidence?
Not guilty plea was entered at first appearance on May the 18th. This expedited hearing was set.
Not guilty again.
I understand. Not guilty plea has already been entered.
Trial.
On behalf, Mr. Brundage. I'm still a little unclear. About your dissatisfaction with Mr. Patterson and extremely.
I'm defending myself.
Attorney.
Now this is where things get interesting. The defendant is insisting on representing himself despite repeated warnings from the court. Legally, that's his right, but it's often a risky move. Imagine trying to navigate courtroom rules, evidence procedures, and legal arguments without formal training. Would you represent yourself in a criminal case?
Mr. Brundage?
I'm defending myself.
The court advises against that.
I don't care. I know you do, but I don't care.
If the court were to relieve Mr. Patterson,
I'm not going to let you. I'm not going to let you make another choice. Just like you made Patterson, I am defending myself. I have enough knowledge. I've got 30 years experience in being in the court system. I'm very confident.
Okay. You understand that these are Class B misdemeanors.
And I understand you've held me longer
by up to 6 months in the county jail and up to a $1,000 fine, or both, as to each count.
How long can you hold for a misdemeanor? You think you've already held me long enough? That's wrongful jailing.
Have you just failed to make bond in this case?
I'm homeless. Have you failed to have a heart?
Okay.
You've got an extremely low bond. You gave me $700 cash. You gave me $700 cash.
$750 cash or professional surety. Is your current bond.
I have no money, and I was living along the railroad tracks, sir. You have no heart. I understand. I understand that totally. But I am homeless, and I'm not going to have anybody who gives a fuck to help me. That's just how it is.
Just watch your language, Mr. Brundage. You don't need to go there.
Have a heart to go there. You don't have to go there.
Mr. Patterson, do you have any remarks? At this
I don't want Patterson involved in anything.
Just be quiet for a moment. I'm addressing Mr.
Did you catch that? Defense counsel just raised concerns about competency. That's a serious issue in any criminal proceeding, because the court has to ensure a defendant can understand the case and assist in their defense. The judge is now balancing constitutional rights against concerns about the defendant's ability to proceed.
Patterson.
Your Honor, I did go out to the jail. I did attempt to meet with Mr. Brundage. We had a very brief conversation, and it ended with Mr. Brundage saying he wanted to represent himself, did not want to discuss the case with me at all. talking with him though and reviewing the case, I had a concern of competency, but I can tell the court he didn't talk with me enough for me to ferret that out and make a final determination myself whether I thought there was an issue or not. So I can't report to the court whether there is or is not a competency issue, but I do know he wants to represent
Nice
himself.
try.
Right.
My thing,
Just a minute, Mr. Brundage.
my thing.
Just a minute, Mr. Brundage. Mr. Regier, as prosecuting attorney appearing here, are you aware of the pendency of any other cases involving Mr. Brundage, which are currently pending in the Butler County District Court?
Augusta, I filled out police brutality paperwork. Mr.
Regier.
And there it is. The judge grants the request for self-representation. But here's the catch. Representing yourself doesn't mean the rules change. The court expects the same standards from a self-represented defendant as it would from an experienced attorney. That's a much bigger challenge than many people realize.
Not at this time, Your Honor. It would appear that another case did proceed to sentencing before District Judge Crum approximately 2 weeks prior on May 19th.
Can I ask you a question, Ricky?
And forgive me, Your Honor. That would appear to be May 19th of 2025. I misspoke. I apologize.
What about this fraudulent? What about this fraudulent fake protection orders that were signed by CMC, which is Court Magistrate Clerk, which should have been signed by my parents that I received from Jeffries? Can you explain that to me?
CMC very well may refer to
Court Magistrate Clerk.
From District Judge. His initials appear on many documents.
My parents should have been on them. That's how those things work.
All right. What is clear to the court at this point? Is that Mr. Brundage does not want Mr. Patterson to represent him.
Hell no.
He has made a decision, which is his constitutional right to do, to represent himself, despite the court's admonition for him not to go that route. You're going to be held to the standard of any other attorney would be in the presentation of evidence, following procedural rules, trying your case if it comes to that.
Okay, just one more thing. I want to go ahead and ask for a subpoena on that one that he was talking about with Augusta. I need a subpoena on video, witness statements.
Okay.
Video, witness statements, and management of Walmart, and also Facebook, Twitter, etc., YouTube, WhatsApp. I need all that.
Okay. If you're talking about some Augusta municipal court matters, is that what you're talking about? Mr. Brundage, is that what you're talking about?
Police brutality.
Okay, you understand that would be pending most certainly in the Augusta municipal. That is not in Butler County. That is not in Butler County District Court.
It was supposed to be that, not you.
So.
And there's also a Butler County sheriff officer named Smith that put the cuffs on too tight, and they almost broke my wrist. And they have denied me the paperwork 3 times now for police brutality, and I want to file it for that. It's not officer unbecoming; it's police brutality.
Right, that's something. You can handle with the sheriff's office.
That's what I'm saying. No, they won't do it. That's what I'm saying, Judge Ricky. They will not give me the paperwork. They will not do anything. You're going to have to force their hand.
This exchange perfectly captures the tension in the courtroom. The judge keeps trying to confirm that the defendant understands the consequences of his choices, while the defendant remains convinced he's being treated unfairly. At this point, the case is becoming as much about courtroom strategy as it is about the actual charges that... Question really is at this point, Mr. Brundage, with all of the challenges that you're currently raising. What do we need to do with this case? You're representing yourself.
Set it for trial.
Set it for trial. You committed a not guilty plea.
Set it for trial.
Okay. Since you have 2 counts of Class B misdemeanor, you're entitled to a jury trial.
Aren't you going to OR me out now?
Is that what you're requesting, Mr. Brundage? Are you requesting a jury trial or a trial to the court?
Whichever's going to be the fastest. Because you don't have no evidence.
The decision really shouldn't be made on. The quickest.
How about we put it pending? Let's see that. Let's see that other one pop up.
See what other pop up.
Police brutality with Augusta. Police brutality with Augusta. Put this one pending and put that one through.
All right.
A court trial would be faster.
A court trial would be faster to schedule.
Let's do a jury.
Mr. Brundage.
Let's do a jury. So you're actually on the line.
Well, actually, I think you'd be on the line.
No,
Actually, I
you're
think
on the
you'd be
line
on the
too,
line.
No, you're on the line too as a judge.
All right. You sure this is the route you want to go?
Yep.
You sure this is the route you want to go?
Yeah,
Mr.
that's the route you want to go with me. Sure, that's the
No-
route
no
you want to go
attorney?
with me.
No
That is
attorney.
correct, sir. That is
Whose
correct,
advice,
sir. I'm not being
whose
railroaded
advice,
like
uh,
not being
and
railroaded
assistance
like
is very helpful to you?
I'm not being railroaded like some slave in Africa that's getting off the boat. It's not happening.
Okay.
That's what Patterson's whole intentions were.
All right. Address the court's assistant. I'm going to address the court's assistant.
Just set that other one for real soon. Just set that other one for real soon because I want that police brutality in Augusta to come through.
The next
You're gonna OR me on
the next
you're gonna OR me on some
misdemeanor.
misdemeanors.
I'm
You're not gonna OR me.
I'm trying to communicate here. Jen, do you have a misdemeanor? Jen, do you have a misdemeanor jury trial date? You can.
We do have a pre-trial on August 3rd with jury beginning August 5th.
Okay.
Pre-trial is at 9 a.m.
Okay.
Pre-trial is at 9 a.m. and so is the jury trial.
Very well. Pretrial conferences will be conducted in this case August 3, 2026.
What about the clerk? Clerk on that?
Jury trial set to begin August 5, 2026 at 9 o'clock a.m.
And that's the final ruling on bond. The judge refuses to lower it, finding that the current amount is already minimal. No dramatic last-minute victory, no sudden release, just a firm decision and a trial date on the horizon. The big question now is whether representing himself will help or hurt the defendant when this case finally reaches trial.
Patterson's not allowed. Patterson's not allowed.
I've relieved Mr. Patterson in your case. Mr. Brundage, at this point, your record reflects that you're representing yourself.
How can a $40,000 lawyer represent me?
I don't know what you mean by that. And
He's
I don't know what you mean by that. And
He's $40,000 for a good case. I'm nobody. I got no money. I'm nobody. I got no money.
To represent you. He was appointed to represent you because you
From
were found to
Sedgwick?
be indigent.
From Sedgwick.
What?
From Sedgwick, he's
What?
not a butler lawyer. From Sedgwick, he's not a
Yes,
butler
he is.
lawyer. No, he's not.
Yes, he is.
His cousin. No, he's not.
Okay.
His cousin is.
Okay. Mr. Brundage, were you receiving any mental health services prior
Nope.
to being arrested
Sure
on
ain't.
this case?
Not going to take anything. I'm good. Don't need no medical check. I'm good. Mind like no other. Got a clear mind like no other.
All right, the court has established appropriate pretrial conference and jury trial dates based on the defendant's plea.
You're not going to OR me.
Not guilty.
It's all about money with you. It's all about money with you. Can't help a homeless guy out. Can't help a homeless guy out.
Mr. Brundage, the court's not inclined to modify your bond. It is an extremely low bond.
That is an extremely wrongful imprisonment then. I'm filing charges.
You do whatever you have the legal
I'm
right.
filing
You do
charges.
whatever you have the legal
I'm
right.
filing charges.
I
Write that
review
down on
the
your document.
situation.
Write that down on your document.
I see no societal
Write that down
interest.
on your docket.
Just
Write that down on your docket.
Justice interest that would be furthered by modification of what is already very low cash.
Your wrongful jailing is $500 or $5,000 a day. I'm cool with it. I need the paycheck.
So bond remains the same. Mr. Brundage, the record reflects that Mr. Brundage is representing himself.
Your job's on the line, not mine.
dates.
Your job's on the line, not mine. Have a good day, sir.
Mr. Aguirre, did you have anything else that you wish to make part of this record? Okay.
No, Your Honor.
And at this point, very well. And at this point, the Heath Brundage matter is in recess.
Judge, the
We'll move
deputy
on
seems
to other
to have
matters.
something. Judge, the deputy seems to have something.
Yes?
I'm trying to state my case.
Okay, I can't hear Court Security 3 right now because he's muted.
The pretrial conference was 8-3 and the jury trial was 8-5,
That's
correct?
the dates I was given. That's the dates I was given. 9 o'clock a.m. settings on both.
Courtroom
It
E.
would be before the magistrate court.
All right, thank you.
Yes.
All right, thank you.
Thank you.